Hi, my name is Nadav Ravid. I am the managing partner of Ravid Law Group. Our firm specializes in representing landlords and tenants throughout the country in their commercial real estate leases. Every month, we write about a topic that affects the commercial real estate lease industry. And this month, wrote about the topic du jour, which is the force majeure provisions, how they are being renegotiated in a post COVID-19 world. As you would expect, in the past, while force majeure provisions were relegated to the miscellaneous section, the back of the lease, weren't given a lot of thought. Post-COVID, this is one of the most hotly negotiated provisions, with a lot of parties now really focusing in on the things that we've learned that can go wrong in the relationship between landlords and tenants as a result of a pandemic. So what are people talking about? How are they negotiating these provisions? The first thing is to make sure that a force majeure provision is broad enough to cover things like COVID-19, basically pandemics, epidemics. So what you see is a lot of landlords and tenants are agreeing to expand the old definition of force majeure, which could have covered things like riots or tornadoes, hurricanes, earthquakes, other types of things that are typically considered standard force majeure provisions. And now we've seen parties agree to add pandemics, epidemics, disease outbreaks. One thing you want to make sure is you don't broaden it too far. For example, disease outbreak in it by itself might be too broad, because you could have a situation where there's a restaurant tenant that has its own disease outbreak in its own premises. It has nothing to do with a macro outbreak. And so you want to make sure that you're covering only really superior forces, things that are impacting an entire industry, if not a broad area. So that's the first step of just making sure to broaden what the definition of force majeure will cover, and to make sure that you're including pandemics, epidemics, and things of such nature. The next issue is really the biggest issue that gets negotiated, is what should happen to the obligation to pay rent. Now, historically, force majeure provisions have provided that while the parties may be excused from performing certain obligations, for example, a tenant may not be required to operate if there is a force majeure clause, if there is a force majeure event, or things like that. But in all situations, even when there is a force majeure event, the parties in the past had agreed that the rent would continue to be due, for the most part. You have a few exceptions. And so now parties are revisiting what really should happen in the event of force majeure. Should the tenant still be obligated to pay rent? And the parties have started to really get into the details of how to resolve these issues. So for example, tenants will start off by saying, if there's another force majeure event, if I have to shut down, I want full rent abatement. Landlords are saying that's going too far. And so what are the parties agreeing to? So from a first perspective, the landlords are saying, okay, wait a second. I will give you some relief if there is a government ordered shutdown. While the tenant's perspective is to say, well, wait a second. It may be the case that there's only a government recommendation for a shutdown. As you saw what happened here back in March, it started off with a recommendation before it became an official order to stay at home. So some tenants are thinking that a government recommendation should be the trigger point, but most landlords are resisting that. And they're saying, look, I don't want to get involved with those types of things. It's too, it's just opens itself up to parties getting into disputes, whether or not the intent was to cover such events. So it's a hard and fast rule. If there's a government order, we'll agree in that circumstance, we will give you some rent abatement. Another thing the tenants have responded with is saying, well, wait a second. Okay, it's one thing if there's if there's a government order, but what about if the landlord decides on its own to shut down, for example, a mall? an indoor mall. Even again, so here we are in a situation where there's no government order, but there's an action that the landlord is taking that is depriving the tenant from its ability to operate. So landlords are open to that type of additional protection, but again, don't go too far because you have some tenants that have an outside entrance into their stores. And so the question is, if a landlord shuts down an interior space, that's one thing, but if the landlord's shutting down a mall, but there's still access to the space from outside, then that should not count from the perspective of the landlord. So again, the easy thing to think about is if there's a government order requiring a shutdown, then there will be some rent relief. Short of that, tenants will rarely get some relief. There are some landlords that are open to expanding it to in the circumstance where there's a landlord shutdown of a mall, unless there is access from the outside. The next issue is what should happen if the tenant is still permitted to use the space, at least partially. So for example, a government order might say that we are allowing you to stay open, but a restaurant, you can only have outdoor dining, or a retail store can have 25% or maybe even 50% occupancy. Should there be any kind of rent abatement in that circumstance, from the tenant perspective, their business is hurting. It's better than nothing. It's better than not being able to operate at all, but it's not the same as if, pre-pandemic. And so therefore they agreed to pay rent based on an expectation of being able to use the space 100%. And so landlords are open to giving some partial abatement, but it's very hard to get most landlords to agree. But there are some out there that are open to the discussion. The question then becomes, what should that abatement be? Should it be tied to, for example, if you can only operate from 50% of the space, should the rent now drop to 50% rent? Or what some landlords are saying is they'll agree that the rent should be tied to a percentage of sales in that case. And then the question is, how do you factor in what that percentage should be? And that really gets negotiated on a business level. But most parties do agree that if there's a full shutdown, full government order, then in most cases they will agree to give you either 50% abatement, maybe we split the risk, or 100% abatement in some cases. But in most cases, landlords are asking for an extension of term if that were to happen. So if you get 1 month of rent abatement, whether it's a full or a partial, then you get 1 month of a lease extension. Again, some tenants will say, well, if I only got a partial rent abatement, a 50% rent abatement, then you shouldn't get a day-for-day extension. You should get, for every day that I got 50% rent abatement, you get a half a day extension. People aren't thinking in halves, but if you have a 10-day extension of 50%, then the extension of the term would be for 5 days. Another thing that landlords are saying to the tenants is, hey, we recognize that business interruption may or may not be available today, still being flushed out in the courts, although it does look like the insurance companies are winning in most jurisdictions, that the business interruption will not apply. But the expectation is that things might change. There might be some insurance policies, new insurance policies that will cover for such events. And so what the landlords are saying is, hey, you need to do two things, tenant. Before you can resort to getting any kind of rent abatement, we expect you to carry whatever is readily available, whatever insurance is readily available, some type of business interruption insurance that will cover this. Again, tenants will say, well, okay, as long as it's commercially reasonable. It might be the case that these policies will get issued at an exorbitant price that's no longer commercially reasonable. And then the landlords are saying, and you have to use reasonable efforts to try to recover on those policies. So again, you kind of get into this discussion of, well, what is commercially reasonable? If you see that everybody's losing all these cases, do you need to file a lawsuit? Again, those kind of things, I think parties are agreeing to basically kick the can down the road and just stick to the concept of what's commercially reasonable. Another issue that parties are talking about is notice and whether or not you should be required to issue notice. A landlord doesn't want a tenant to take advantage of these force majeure provisions, especially when it comes to abatement of rent. And so they're saying that, hey, if there's an event, you need to give me notice so that I don't want to find out about this 3 months from now and say, oh yeah, back in March, I closed down for 2 months. And so now we are in September or whatever, and I want credit for that rent that I had paid you. No, if you want to get rent abatement, I want advance notice. Now, when you had a stay-at-home order preventing people even from entering the office, that made it very difficult. You have retailers that have hundreds of stores, and they're going to be able to just start FedExing 100 notices. So one of the things that tenants are asking for and landlords are agreeing, actually it works both ways, is for notices to be sent by email, some electronic form, especially during a force majeure event. And so parties are open to that, that type of a change. Again, some tenants are saying, look, if it's so widespread, if it's affecting the entire country and everybody's well aware of these orders, then maybe notice could be waived in those circumstances. And so there's a bunch of more nuances that get negotiated depending on the industry you're in, restaurant business. I mean, what if you can only do takeout instead of being able to operate as a retailer? What if you can only use your space to ship product instead of being able to even be open? Is that considered being able to use your space? From a landlord perspective, yeah, you're using your space, so you shouldn't be getting any rent abatement, or maybe if anything, it should be some minimal rent abatement. And from a tenant's perspective, obviously they're not using the space in the same way. They're not bringing in customers in the same way that they were before. So those kind of nuances need to get flushed out on a deal by deal basis. But that's pretty much the macro level issues that we're seeing on force majeure clauses. And we will continue to monitor what's happening as whatever the new trends are and whatever new case law impacts these issues. And we will report back to you. That's it. Thank you. Bye-bye.